Now that the dust has settled on the historic news that the Supreme Court has officially granted review to two AR-15 ban cases, which are the Vermontes versus Cook County case and the Grant versus Higgins case, it's time to look at what happens now in this battlefield going forward. We just received our first major procedural development on these cases. The Supreme Court has officially approved a new modified schedule for how these cases will actually be briefed and how they will move forward. So today we're going to talk about the exact roadmap that the Supreme Court has laid out for this upcoming term. We're going to look at the key deadlines, and then we need to actually look at and kind of explain how this brand new joint extension request tells us, how this is likely going to play out as far as the oral arguments. So let's break down what is currently happening. Now, before we jump into this video, if you like this type of content and you want to make sure you get it going forward, make sure to subscribe to the channel. Also hit the notification icon, turn on all notifications to make sure you never miss this information going forward. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always trying to give you as much as possible as a member. They're always expanding upon their benefits to add in things that other companies can't. So if you're interested, you can check them out using the links down below. And if you sign up right now using my exclusive code ARMSCHOLAR, you can get $50 off of your individual sign-up fee or $25 off the family fee, but that's only for a limited time and it's going to end at the end of this month. Now, as I mentioned in the intro, in this video, we're going to be discussing the critical rifle ban challenges that the Supreme Court recently granted review on and that they're going to hear and actually issue their decision on next term. Now, the lead case is the Vermontes versus Cook County case, and we've been following that case for a while. In the Vermontes case, the petitioners challenge Cook County's ordinance, which makes it a crime to sell, transfer, or even possess a so-called assault weapon. That term covers more than 100 rifles by name, including AR-15s and AK-47 style platforms, and also any firearm with features like a pistol grip, folding or telescoping stock, or something like a muzzle brake. Now, by violating that ordinance, you can have your firearm seized, or there could be fines up to $5,000 or potentially even jail time. Now, the plaintiffs argue that this ban doesn't just regulate firearms. It outlaws some of the most common and popular rifles in America, which are protected under the Second Amendment. Now, in the other case, Grant versus Higgins, this is a challenge to Connecticut's outright ban on AR-15 style rifles and other semi-automatic rifles. Now, here's how we got here in the Supreme Court. Essentially, back in 2021, the Vermontes lawsuit was filed in a federal district court out of Chicago. Petitioners challenged the county's ban under the Second Amendment and also the 14th Amendments. And essentially back in 2024, while the case was still pending, Illinois passed a statewide assault weapon ban overlapping with what Cook County had in its restrictions. Around that same time, the Seventh Circuit decided a case called Bevis versus Naperville, upholding Illinois' law and claiming that AR-15s were too militaristic to be protected arms. They ruled that firearms that are useful in military service could be outright banned. The district court, bound by earlier Seventh Circuit precedent that was just issued in that Bevis case, ultimately had to rule against the plaintiffs in this Vermontes case. And then in 2025, the Supreme Court issued a denial of the Snope case dealing with also AR-15 bans, and then this Vermontes case was upheld and the Cook County ordinance was upheld. And again, they found that AR-15s are essentially civilian versions of M16s, that they're dangerous and unusual, they're too militaristic in nature, and therefore they do not have two-way protections. That then led the Vermontes case to seek Supreme Court review. All last term, the Vermontes case and other cases were relisted multiple times, some of them almost 20 times, but eventually at the end of the Supreme Court's last term, we got the order from the court where they granted review to these two cases. Now, the question that the Supreme Court will answer in these cases is whether the state and local bans on semi-automatic rifles like AR-15s violates the Second and 14th Amendments. And now this case is moving towards the oral argument phase, which will happen this upcoming Supreme Court term. So on July 14th, 2026, the attorney representing the petitioners here, the individuals that are challenging the Cook County ban, they submitted a formal letter to the clerk of the Supreme Court, and the parties requested a joint extension on behalf of all the parties. On July 15th, 2026, the Supreme Court officially granted that motion. So now we have a very clear roadmap for how this AR-15 case will now move forward. On August 28th of this year, the petitioners need to file their merits brief and their joint appendix. This is the kind of the opening arguments of this case. The gun rights advocates will lay out their core constitutional arguments under Bruen and Heller, explaining why AR-15s cannot be simply outright banned. Then on October 21st of this year, the Cook County representatives and the other respondents, the state of Connecticut, will file their response briefs. Essentially, they will argue and try to submit their defenses for why these bans are constitutional. They will try to argue why these semi-automatic rifles represent a distinct danger that falls outside the history and tradition of the Second Amendment. Then on November 20th of this year, the petitioners here will once again file a response to that. They will file that written response trying to argue against what those gun control advocates in those states are arguing. And then eventually, once that's all submitted, once the November 20th briefs are submitted, all the papers will kind of be done. The paper war will be over. And then this case will be fully teed up for the Supreme Court to hear arguments. So what does this timeline tell us about when the live public oral arguments will actually happen? Well, in the joint request, the parties explicitly noted that this specific schedule is designed to accommodate the court's December 2026 argument phase, or potentially the January 2027 sittings as well. So this is incredibly important. It means that we won't have to wait until late spring for the oral arguments. The court is on track to hear the live arguments in this case on the constitutionality of these AR-15 bans, potentially by the end of this year. From there, we will enter kind of that final phase where the Supreme Court will be drafting the opinion. And because this is a kind of a high-profile, highly anticipated constitutional ruling, the Supreme Court will probably take their time. We should expect a final landmark decision on this issue to drop at the very latest, probably towards the end of the Supreme Court's term, probably around June of 2027. There is a chance that they could release the opinion earlier, but the Supreme Court has kind of this track record of leaving these high-profile two-way cases until the end of their term, and that's usually when they release those rulings. So as we march towards these deadlines, the next major milestone to kind of keep your eyes on is that August date where the briefs will start to get filed. And then we will also see a lot of amicus briefs that get filed in support of both sides. We expect a massive coalition of pro-2A states, civil rights organizations, and even members of Congress to file briefs in support of the petitioners. And we will likely also probably see the Trump DOJ file support in maybe the form of an amicus brief, and then later also likely asked to participate in the arguments themselves. Now, on the other side, you will have the gun control organizations and the anti-gun states that will coordinate and try to back Illinois and Connecticut and support their ban. And so they will file those amicus briefs as well. So the timeline for the most important and anticipated gun case kind of our generation is officially locked in. And now we have the dates that this is going to move forward. If you want to stay on top of all of these developments as this case moves forward, make sure you like, comment, subscribe, and turn on all notifications to make sure you never miss these updates when I release them. Also, let me know in the comment section, what do you think about the potential that this could be argued and heard in front of the Supreme Court by the end of this year? Do you think that it's going to happen that fast? And really, how fast do you think that the Supreme Court will issue their ruling after that? Let me know your kind of guesses down in the comment section down below. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.